I want you to be extremely loud and public. Oh, I don't.
It's going.
Recording in progress.
Mute that bad boy. Are you going to be yelling out in the hallway? You're going to be my relay? All right. All right, are we ready? All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When you hear your name, please say present or here so I can write you down. Christy Conger.
Christy Conger. Present.
Sanaya Jones. Or Sinya. I think it's Sanaya, but present. Elkin Martinez. Excellent. Miranda Opry.
Miranda Opera. No, Your Honor.
Miranda Jill Opry. Okay. Katie Williams. Excellent. Olton McCurley. See Mr. Bingham.
He's here, he's present, Judge.
Thank you, sir. Michael De La Rosa.
Present.
Thank you, sir.
Mr. Bowden's here.
I saw Mr. Bowden. There he is right there.
Right here.
He's hiding in plain sight. Lonnie Richardson.
Lonnie Richardson. Present, Your Honor.
Christopher Watson. Christopher Watson.
Present.
Richard Balboa.
Richard Balboa. No, Your Honor.
Mr. Manning, you know anything? Was Mr. Balboa to plead today?
If I may, probably chat.
Sure. Jason Barnes.
Judge Barton is here.
Thank you, Mr. Manning. Glenn Christopher. Thanks, sir. For the record, CR 22-174, Kimberly Ray Cohn wins the dismissal lottery today. State has filed their motion to dismiss. Court has granted that. If Miss Cohn is here, her. All right. Is it Cohn or Cohen? Is it Cohn or Cohen? Con? I didn't think there was a third option. All right, Ms. Con, the state has made a motion to dismiss your case and the court granted that, so you're free to go.
Thank you so much.
You're welcome.
That's a response you want.
I tell you. I didn't ask her to do that either. Jerry Ann Heath. On her way. Dennis Ray Jones. We have a note. Mr. Jones's mother called, indicated that he has court in Cherokee County at 8 a.m. and he will come to Van Zandt County. Are you getting this, Mr. Manning? And he will come to Van Zandt County when he is done, unless, wait for it, he is arrested. So I'm not sure if he is being pessimistic or he can see the future or he's being a realist. But anyway, that's the note that we have. We'll wait. We'll see if We'll see if he shows up.
Subbed in on his case, and so I haven't had an opportunity to contact with Mr. Jones. See if I can.
Maybe the mother knows something we don't, but we'll find out soon. We'll recall his case before the close of the docket. Let's see, John Lejean,
So she's good.
Travis McKibben,
Travis McKibben. Present.
John Piercefield.
Present.
Thanks, sir. Trammell Price.
So she's good.
Thank you, Mr. Manning. Stephanie Rios, the note I have says Denton County, you've confirmed that, Ms. Abraham? Okay, Mr. Manning, Ms. Rios has been confirmed. You know that?
Yes, sir.
Okay. All right, we'll recall her case and schedule her for a status. Michael Sanders. Jay Sean Spencer, Mr. Manning filed a waiver of arraignment that was approved and granted. I believe pretrial is set January 26th. Is that correct?
Correct.
Is there a reason we were setting those out so far?
Judge, I believe Mr. Spencer is on the state, as well as Mr. Mr. Tienda Flash. I have not received all the discovery in this case, so the request additional time to review that.
All right, CR 22-295. Avery Tienda, waiver of arraignment filed, approved, pretrial set January 26th. Brandon Sanchez, waiver of arraignment filed by Mr. Schmidt, approved. Court has set pretrial December 13th. Michael Chitty, Mr. Stevens filed a waiver of arraignment that's been approved and granted. Pretrial is set November 22nd. Also CR 22-308, both cases. Guy McSpadden.
He's in the hallway here.
Thank you, Mr. Stevens. William Lamy, waiver of arraignment filed by Mr. Willett. That's been approved. Pretrial is set November 22nd. William Hayes.
Present.
Thanks, sir. All right. Excuse me. All right, is there anyone who's present in this courtroom right now that can hear me and I've not called your name and you think you're on today's docket? Will you call the hall, see if there's anyone who's not heard their name called? Hits just keep on coming. We did call Miss Heath. Tell her she just didn't hear her name called. Yeah, she's on the bottom of page 3. That's the one that I believe Mr. Nicholas says she was on her way. Anyone else? All right, we have any counsel that's ready? Mr. Bogan? And any other counsel that's not familiar with the course procedure, if you'll just stand up and approach, and I'll get you in and out as fast as I can.
Mr. De La Rosa's case was set about.
Mr. De La Rosa, come on up. Let him come up here so I can make sure he hears what's going on. This is CR 2215, CR 2264, State versus Michael Elias De La Rosa. Go ahead, Mr. Bogan.
Originally, I was going to just request, set this for jury selection after speaking with this would like to turn to the state. I think we both agreed that another docket call announcement would make the most sense in this case.
Judge, we set for a final docket call, Mr. Bogan and I think have just a little bit more discussion to be had, decide whether we're going to resolve this by if we can set it or not.
Okay. All right, we'll set one final docket call. Are you available, Mr. Bogan, on November 8th or 10th?
Sorry, the 10th would actually be great.
Okay. All right, Mr. De La Rosa, you're set for Thursday, November 10th. We will be in the Justice of the Peace Precinct 2 courtroom, which is across the street about a block. Okay. That will be at 9 a.m. Once you sign and get your reset notice, you're free to go.
Yes, sir.
Is that all you have, Mr. Bogan?
Yes, that's it.
Thank you, sir. Good to see you. Yeah, you just right there. That's perfect. Thank you, sir. Mr. Bingham,
Judge, good morning.
good morning. How are you doing, sir?
Doing great. There's a remote set.
Is Mr. McCurley in the courtroom? Oh, there you are. Okay. All right, this is cause number CR 1282, State versus Olton Dean McCurley. Sorry to interrupt. Go ahead.
No, it's fine. We've been talking to Ms. Curry. She's been handling this case with us from the get-go. To let the court know, there's a couple of issues. I think the one that's first and foremost is most of the paragraphs deal with the taking of a polygraph examination. This year, they were administered in April, May, and June of this year. In July of last year, July 30th of 2021, the court amended the conditions to specifically order that polygraphs are to be given in January of every year, beginning in January of this year. So in talking to his probation was transferred to Hopkins County, and then probation officer named Chris Cruz. I asked him about that, and his saying was, we were not aware that the court had made the order, we did not order them. Without getting into a whole lot, I talked to Todd on this story. This is an issue that we were hoping at some point to meet with. I understand you we're not friends today for good reason. So we're hoping to talk and maybe have this resolved. I think it was just an issue with the probation officer not knowing. And there might be other conditions that are like, I think all those center around those. And then you have the 42A, I think it's 258, I might be wrong, but polygraphs are uncorroborated on a basis for revocation. You cannot adjudicate based on a polygraph examination, it's uncorroborated. So there's a whole bunch of issues that we're looking at. We just want to set it off with a talk to Mrs. Curry to see if we can bring us stuff.
Okay. So typically what I do is I'll set off to the next month's contested docket. So that gives us a deadline. So I would set it for November 29th, and that would be a contested docket day.
Yes.
And so if there's no agreement, then the state would argue their motion that day.
All right, and I'll. So I have a medical procedure on the 30th, surgery, and I'm prepared for it on the 29th. I could be here if it's in the morning, afternoon would be different.
It'd be in the morning. As long as he's on bail, it'd be in the morning. If he's in custody, it'd be in the afternoon.
Okay, he's on bail, so I work.
Okay.
Appreciate it.
All right. So Mr. McCurley, once you sign and get your notice reset, you're free to go.
Maybe 9 o'clock.
9 o'clock.
Thank you.
Good morning. Your name, sir?
Rick White and Eric Whitman.
All right.
Your Honor, we have 7 cases, set. I didn't know if you even put all 7 of the docket numbers on one slip. Or
Yes.
still have 7.
No, we'll try to work smarter today. So if you put them all on one,
Appreciate that.
I'll save you from getting carpal tunnel, and you'll save me from having to order more forms.
Appreciate that.
All right, this is cause number CR 22-303, 304, 305, 306. And did you have more than that? Those are the 4 that I'm showing on the docket.
We had an additional 3 that were added, Judge, after indictment. We do not have those case numbers, but he has been taken into custody on those and released on bond. On the 3 new cases, I believe they are 301.
Okay.
I only see that there's a 302. Yeah, 302 and 301 also.
Okay. Let's go ahead and I don't show they're set for arraignment today, but you have no problem arraigning your client today on those.
No, You're not.
Okay.
All of the,
All right. Where is Mr. Hayes?
He's on all.
Okay, yeah, go ahead and bring him in so he can be a part of this. Good morning, sir. All right, Mr. Hayes, you were set for arraignment today. Mr. Wyatt, does your client waive the formal requirements of arraignment?
Yes, sir.
And you've been presented with a copy of the indictment in each cause?
Yes, sir.
Is his name spelled correctly?
Yes.
Enter Mr. Hayes' plea of not guilty into the record, and the court will set this matter for pretrial. Let's see, we have theft, deadly conduct. What are the charges in 301 and 302? Just because I don't have them on my docket.
They are child endangerment charges. Then we have a deadly conduct charge. 3 of those, and then a criminal mission charge.
Okay. Let's see, due to the number of charges, I'd probably look to set this in December to give you time to get the discovery, have time to review it, file any contested pretrial motions. So typically the way my court works is I'll have 3 settings. We'll go arraignment, then we'll go to pretrial. You'll file any of your contested pretrial motions. So motions in limine, things of that nature are going to be carried to trial, but if there's a suppression issue, a quash, dismissal, something like that, that's going to need some kind of oral argument, then would set that on a special evidentiary docket. Once we pass that, then we'll get to docket call. And if there are none of those, then you'll still get arraignment, and then that pretrial setting, if there are no contested, then we'll move right to docket call. And that docket call will be when I expect the state and the defense to tell me if they're going to plead the case or not, and then request a bench trial or a jury trial.
Yes, sir.
All right, so a couple dates I've got in December. If you have your calendar, and please refer to it.
Yes, sure.
Want to make sure we try to get a date that works for y'all as well. I've got December 13th. I got December 1st and December 13th.
Judge, I have a jury. I think so.
On each one of your charges. And gentlemen, that day, our court is still moving because we've been ousted out of ours due to damage. So if it's not repaired by that time, we will actually be in the Justice Court, precinct 2, which is about a block north of here.
Yes, sir.
My coordinator can send you the address for that, but it's just right across the street.
Thank you.
And let's see, I'm also, Mr. Wyatt, I have conditions of pretrial release. I don't know if Mr. Hayes has met with the pretrial release officer, but I'll have conditions of pretrial release where he'll have to report, and that's Mr. Waddell behind you. He's the pretrial release officer. And so all defendants are on conditions of pretrial release once they're magistrated and then indicted and arraigned. So Mr. Hayes will have to report to the pretrial release officer, be drug tested, do those things to make sure he's in compliance with those. And so Mr. Hayes, I would tell you that any violation of the pretrial release condition could result in the court finding your bail to be insufficient and putting you back in jail. Okay, so that means no new crimes, no drugs, and no failures to report. Okay, so once you sign and get that, then just meet with Mr. Waddell. He'll walk you through more of that. If you have any questions, he'll be able to answer them for you.
Okay.
All right, thank you, gentlemen. And the white reset will stay with me, and the yellow goes with Mr. Hayes.
Thank you.
You're welcome. All right. All right, this is cause number CR 2236. State versus Guy Ezekiel McSpadden, and we're set for Docket Call, Mr. Stevens.
Yes, sir. At this time, we have to set a jury selection.
All right, and can you tell me what the offer is from the state that the defendant's rejecting?
I believe the current offers 5 TDC. I have provided some information to the state this morning that they're gonna take a look at. It may end up resulting in a different offer being made, but I think the court advised us it's our last chance, so we're gonna go ahead and set it this. I'll leave it 5 TDC.
That's your understanding, Mr. McSpadden, of what the offer was? and state, is that your best offer?
Judge, that would be our best offer.
Okay, all right, and so, Mr. Stevens, Mr. McSpadden understands that the court's not going to entertain a plea bargain at a later date.
Yeah.
Okay, all right, then, the court will set Mr. McSpadden for jury selection beginning Monday, October 31st. Mr. McSpadden, you'll report here to the courthouse. Right when you enter the door, Ms. Taberham or another one of my staff will be out there. You won't go to trial that day, but you'll get on the trial process, and so you'll come in, you'll get a reset notice, and then you'll be sent on your way. And until your case reaches the top 10, then Mr. Stevens will not be required to be here. So it won't be a court hearing, won't be a court date, but you will be required to appear, and you may check in with your pretrial release officer. They may be here as well. You'll get your notice of setting and they'll send you on your way. Okay.
And it's at 9 a.m.
Come early, come at 8:15, 8:30, so you can get in and get out. Okay. All right. Yes, can I see you before you go, Mr. Stevens? Good morning, Mr. Donovan. Do you have your client in the courtroom?
Yes.
All right, come on up. All right, this is cause number CR 21-404-405, State versus Lonnie Jean Richardson, set for docket call. Go ahead, Mr. Donovan.
Yes, sir. Last time we were here, I requested one more docket call, to get together basically, resume. My client has got everything together, it just needs to get the state yet. I asked for one more docket call, but we said there a about it. I can, and I understand the court's decision.
Yeah, I mean, it really doesn't do me any good to call something final if I don't enforce it to be final. So, Mr. Richardson, you understand that after today, there will be no plea agreements.
Yes, sir.
And that means we're gonna go to jury trial if that's what you want to do.
I thought it's fine, we could also resolved without a jury as open, there was some slow, some of it.
All right, court will set Mr. Well, let me hear, what is the offer that Mr. Richardson's rejecting today?
Judge, I believe it was 15 TDC on the manufactured delivery case, or 9 on the aggravated assault with a deadly weapon case. In either case, we would 4.5 the other case.
And you're rejecting that, Mr. Richardson, correct? Is that a yes?
Yes.
Okay. I just have to have you say yes or no, so for the record to be clear. Okay. All right, court's going to place Mr. Richardson on the jury selection docket beginning Monday, October 31st. So, Mr. Richardson, you'll report to the courthouse at 8:30 a.m. When you come in, you'll meet my staff. They'll check you in and they'll give you your next date. You'll continue to do that until your case is reached for trial. You're going to start the process on Monday, the 31st, Halloween, but you will not be going to trial on that date. So that means Mr. Dom is not going to be required to be here to check you in, to get you reset and gone. Okay. All right. Once you sign and get your notice of reset, you're free to go.
I also have Mr. Watson today. I talked to. We filed a motion to withdraw on Thursday this morning.
See you in the courtroom. All right, it's cause number CR 22198, State versus Christopher Storm Watson, and we are set for pretrial. Let's take up the pretrial first, and then we'll do the motion to withdraw. Are there any contested pretrial motions filed?
No.
All right. All right, so Mr. Watson, Mr. Dahman has filed a motion to withdraw. Mr. Dahman, I think I've seen that motion. Is it compensation and failure to communicate?
Oh, it's compensation.
Just compensation? So Mr. Watson, what do you do for a living?
I work at a hospital,
What do you do for them?
caretaker. That just working at a nurse's assistant.
Is it tough work? Do you do it for free? Hmm.
No.
Do you expect Mr. Dahman to work for free? And his work can be hard and challenging too.
It's very hard.
So what are you going to do if the court allows Mr. Dahman to withdraw as your attorney because he's not being paid because, like you, he doesn't want to work for free? How are you going to handle this case? Are you going to represent yourself against these trained lawyers?
No, sir. Right now.
Have you talked to family, friends to see if you could raise the money that you need to pay Mr. Dahman or hire another attorney? And what's the outlook on that?
Hopefully positive.
If I give you some time, how much time do you think you would need to, do you want Mr. Dahman to be your attorney? Okay. And how much time do you think it would take for me to give you, for you to keep Mr. Dahman as your attorney so the case keeps on moving like it has? Month? Okay, so today we were set for pretrial. What I can do is I can set you for docket call. And give you that 30 days, but if that 30 days comes and goes, then you may be faced with being put on a jury selection docket without a lawyer, because there's not a lot of work that Mr. Dahman is going to want to do between now and then because he's not getting paid, you understand? So you can't expect him to be trying to figure out what they're offering or what they intend to do, because it'd be exerting his time and effort in doing that. Okay. So I'll tell you what I'm going to do. I'm going to reset this for pretrial. I've noted for the record, you've got no contested pretrial motions, but I'm going to reset it for pretrial so that Mr. Dahman doesn't have to work anymore on the case, more than he already has. I'm going to give you 30 days to see if you can get your issue with him resolved. If not, then we're gonna take it up again at the next docket. Let's see. Mr. Dahlman, you have your calendar with you? I tell you what, I may bump it out a little bit further. How about December 1st?
I believe, I will be here.
All right, Mr. Watson. So I'm going to give you a little longer than 30 days to try to help you. All right. So the court's going to reset you for an additional pretrial December 1st. That would be at 9 a.m. And I want you to think about the situation that you're in. I'm assuming that you already have and what you're facing, right? And you don't want to face it without an attorney. Promise you. Okay. So it's in your best interest and your loved ones that you have a lawyer. Okay. All right, court's going to reset Mr. Watson then for December 1st at 9 a.m. Once you sign, top of page 3. Yeah, on my page 3, top of page 3. It should be alphabetical by your name on the right.
Oh.
It's on my page 3, Patty. Or our doc is different.
Richard has already found, but not looking at she will arrange her.
I'm not hot right now. Did you already put these under Richard's name?
No, they're just going, they're on page 1 and 2.
Oh, okay.
My sister, Ryan.
Yes, thank you, sir. I thought you said that it was Richard's and he would.
One's Richard, one's one.
Oh.
That's right. Top of page 2. And he will arrange.
Second. Mr. Manning, are you ready, sir?
Judge, I have a couple ready.
Are you ready on? Mr. Lejean?
Sure.
He looks ready. He started getting up. What's that called? The power of persuasion or? CR 21-402 State versus John William Lejean Jr. set for docket call.
Yes, Judge, we're request, we got an offer on short on. Time. My client is not ready to accept at this time. He requests additional time to discuss some of the consequences of that plea. As we request for additional If I remember correctly, last setting, he was actually for something set on a Tuesday at most point, but didn't get a chance to talk to him at that setting about the state's offer and position where we were. So we were in this position.
So how long has the offer been made and how long has Mr. Lejean had to think about it?
Judge, I don't have that listed. I know that we first filed a waiver of arraignment in this case in July. In May, we were set for first pre-trial in July. I met with my clients in May, right after he was appointed, and reviewed videos in September. So that's the notation. Keep the case, move at a decent pace. It's just with the TDC operator, make sure that he has his.
State, do you know when the offer was made or placed into your system?
Judge, this most recent offer, I think was about a month ago, maybe it's probably right before our last docket setting. Sir, and discussing that he was unable to speak with his client because of us being there. And I don't believe, I think that was one of the ones that I was not present for. State's not opposed to a final docket call on this.
How long do you need, Mr. Manning?
Yeah, just regular, 1 second.
You want the November 10th or December 1st?
Judge, if we're gonna have December 1st.
All right, Mr. Lejean, court sets you for docket call on December 1st. That'll be final docket call.
And Judge, I have explained to him the process and asked for docket call, and he is aware that if he chooses to reject at that point in time, that there are no other offer will be entertained by the court.
Also have a concern about pretrial release with Mr. Lejean. I've got notes saying that he failed to report in August and September and that he's delinquent almost $300.
Judge, my understanding is that was called this morning, I was not aware of any.
Can you stick your head out there and see if you can find Coral? Mr. Waddell had notes that Mr. Lejean failed to report for the last 2 months consecutively and is not paid up to $300.
He paid this morning. And he has reported, but he didn't return his form in June. And as I told him, if that would give me back this form. He gave it to me today, and I remember seeing him, but he did not turn his form in, and that's the only way I can confirm that he reported that.
And you said he paid, how much did he pay? Is he still delinquent $300
I believe he paid $250 today.
today?
Yes, sir. I saw the receipt.
All right, so you're comfortable with Mr. Lejean that he's in substantial compliance?
Yes, sir.
All right, Mr. Lejean, you understand what Mr. Waddell is saying as far as that form? He's got to have that form. He sees a lot of people.
I got back and I thought, the moment he keeps it, and I was like, oh, okay, that's only met for the point. I thought, I'll make sure I think that's.
Okay, just make sure you,
I
my,
got a green now, so.
yeah, my advice to you is to make his job easier.
Right.
Because you see, I'm gonna call him in and I'm gonna ask him to tell me what he thinks. So if he's thinking you're doing good, then you're off my radar. Okay,
Absolutely.
all right, Mr. Lejean, you're reset to December 1.
Mr. Christopher.
All right, Mr. Christopher, step on up. Glenn Christopher, CR 22-206 for pretrial.
Yes, Judge. We're gonna request additional fee trial. Mr. Christopher was hit by a truck.
Yeah,
18-wheeler, and so we were unable to get him in, the scheduled appointment to go over the discovery. The cattle discovery, I believe, I just didn't have an opportunity to sit down and go over it.
Okay. You want that 12-1 date?
That'd be great.
All right, court recess, Mr. Christopher, then for additional pretrial to go over discovery December 1st at 9 AM. Once you sign and get the yellow copy, free to go. You ready on Mr. Piercefield?
Judge, we can do Mr. Christopher.
Oh, I'm not trying to force you one way or the other. I'm just asking.
No, Judge, I'm actually gonna announce, I have a comment, I spoke to Mr. Pierce before, I have a comment, I represent the co-defendant in this case. So we'd ask that, additional. Counsel be reported.
Okay. All right. Go ahead and have a seat, Mr. Piercefield. Let me talk with Ms. Tabraham and we'll get a new court appointed attorney for you that doesn't have that conflict.
Mr. Sanders.
Michael Dean Sanders, CR 22-228.
Judge, we received a new offer on Mr. Sanders' case, that he was wanting to pursue, it requires some, money, be paid, and we're going to pay up front. If we could reset for Docket Call.
I show this set for pretrial today. So
We don't have any contested fee trial, so if you want to go plea or want to Docket Call.
please sounds better to me. Sounds better to you. You want to do that 12-1 or 11-10?
Let's get 12-1 so we can ask more time.
All right. Court sets Mr. Sanders for plea on 12-1 at 9 AM. Once you sign and get the yellow copy, you're free to go. Well, Jonathan's not leaving. He just needs more time, I think, on some other things. No, let's not appoint Richard. Let's do Bill Stevens. Let's see if Bill can do it. All right. Anyone else?
Mr. McKibben.
All right, Travis McKibben. CR 22-222 set for pretrial.
Yes, Judge, at this time, issues the receiving offer, we would request opportunity to give, any come up, test of control, to have it, ask for dollars.
All right, court will set Mr. McKibben for docket call 11-10 or 12-1.
11 to 12.
All right, court sets Mr. McKibben for docket call 11-10 at 9 AM. Once you sign then and get the yellow copy, you're free to go. And Mr. McKibben, have you been paying on your delinquent?
No, sir, I never made.
Okay, I want you to go up and check with Ms. LaPrade so that she knows. I don't know if you're staying in contact with her, but you need to. Okay, so go up and see her before you go. You're welcome.
Jury and
Jerry and Heath, CR 22-313, set for arraignment.
Judge, Ms. Heath's name is spelled correctly, she understands the charge against her, understands the range of punishment, and it's time to be being done.
All right, court will find that Ms. Heath has waived the formal requirements of arraignment. Court will enter her plea of not guilty. Court will set her for pretrial. Do you want that 12/1 date to give you more time?
Judge, we can actually probably do the one themselves.
11/10. All right, court sets Ms. Heath in for pretrial on November 10th. That'll be at 9 a.m. And then Ms. Heath, I'll need you to sign the court's conditions of pretrial release before you go today. I don't know if you've met with the pretrial release officer, Mr. Waddell, yet. Right. That's why I'm telling you. So there's going to be conditions that you have to comply with while you're pending trial in this case. Those conditions are going to be that you have to report to a pretrial release officer. You have to drug test. You have to stay drug-free, of course. Can't commit any new crimes. You have to reimburse the county for Mr. Manning's fees. All right. And so any violation of any of those could land you back in jail. Okay, so get that yellow copy and then go, Mr. Officer Machera, this is Miss Heath. She needs conditions of pretrial release.
Mr. Price.
Trammell Price, CR 22-248. Trammell Price.
Judge, we're set for pretrial today, we reached an agreement, with the state, request to be set for a plea on December 1st.
All right, court will set Mr. Price then to enter his plea before the court December 1st at 9 a.m. Mr. Price, once you sign and get the yellow copy, you're free to go.
Yeah, thank you.
You're right.
Very good. Thank you.
You're welcome.
It's override.
Yeah, I'm gonna let him call her name. Good morning. Is it Opry? Opry. And I'm like 0 for 2 today. Opry. All right, CR 22-280-281, State versus Miranda Jill Opry. I'm gonna mess that up again in the future, so I'm just gonna go ahead and ask for your forgiveness. Go ahead, Mr. Manning.
It's no more, this is what she was actually over at JP
2.
2. And so she also, she found out, we've gone over the indictments, both charges, standard rate of punishment, she understands those, her name is spelled correctly, and someone not guilty. We get the December 1st date.
All right, court will find that Ms. Opry has waived the formal requirements of arraignment. The court will enter her plea of not guilty into the record for both charges and set her for pretrial hearing on December 1st at 9 a.m. And Ms. Opry, the court has conditions of pretrial release that you're going to need to sign. I don't know if you've already met with a pretrial release officer. You've got those? Okay. So those are going to be conditions placed on your bail. And if you violate, you don't report, you don't pay, test positive, any violation of any of those will land you back in jail during the pendency of your case. Okay? All right. So once you sign the notice of setting and then meet with a pretrial release officer, then you'll be free to go. Okay?
Judge, if I may have just a moment, I have a couple more, but I would then get through as well, still trying to follow with Mr. Malone. I've also been getting a couple of appointments this morning, one with myself and one with Mr. Schmidt.
Yes, sir. Take your time. Mr. Versace, are you ready?
Yes, Your Honor.
Is your client in here?
Please, Your Honor. Yeah.
Yes, thank you, sir. All right, Ms. Conger, this is CR 22-207. Your name is Christy Marie Conger.
Yes.
Correct. Ms. Conger, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
All right, you can lower your hand. All right, Ms. Conger, you are a United States citizen, is that right?
Yes.
And you do read, write, and speak English. Will you close that door? Thank you. And Ms. Conger, have you ever been diagnosed with any type of mental condition?
Anxiety.
Anxiety? Are you on any kind of medication or undergoing treatment for anxiety?
Less.
Okay. And so you don't feel like that anxiety is affecting you in any way from having a rational understanding of today's proceedings and what's going on?
Yes.
Okay. And you've taken the time to read over the paperwork that you want the court to approve, which is your plea agreement, the judgment, these other things. You've taken the time to read over those with your attorney, Mr. Versace. Is that correct?
Yes.
You feel like you understand everything that you've read and signed.
Yes.
You feel like you've had enough time to discuss this case with your attorney and have all your legal questions answered.
Yes.
And are you pleased with the representation he's provided you?
Yes.
Mr. Versace, do you believe Ms. Conger to be competent today?
She is, Your Honor.
And you've explained to her all of her rights as they pertain to this case?
Yes, Your Honor.
All right, Ms. Conger, it appears that you were originally indicted with a third-degree felony offense of assault of a public servant, which is a third-degree felony, which does carry a range of punishment of 2 years to 10 years in prison. However, the plea agreement today appears to be that the state would be offering you a lesser included offense of a Class A misdemeanor assault causes bodily injury. And upon your plea of guilt, their recommendation to the court is 13 days confinement in the county jail, with you receiving all 13 days credit, a $2,000 fine, plus $270 court cost, $35 reimbursement fees. You would have DA 2021-1493, a resisting arrest, search, or transport considered and dismissed with your plea in this case. Is that your understanding of the plea agreement today?
Yes.
All right, so the range of punishment for the lesser included offense, a Class A misdemeanor, is confinement in the county jail up to a maximum 365 days and a fine of not more than $4,000. And I find that this plea agreement would fit within that range. So understanding the plea agreement, understanding the range of punishment, Ms. Conger, how do you plead to assault causes bodily injury, a class A misdemeanor?
Guilty.
Are you pleading guilty to that lesser included crime because you are guilty of that crime?
I didn't, the second one, I didn't,
Are you pleading guilty?
yes,
Yeah, maybe I didn't ask it in a simple way. You were charged with assault of a public servant, which is a higher charge. Today's plea is for a lower charge, a class A misdemeanor, but that charge is still assault causes bodily injury. Are you pleading guilty to assault causes bodily injury, the lesser crime, because you did in fact commit that crime?
yes,
Okay. And has anybody threatened you, forced you, or pressured you to plead guilty to that lesser charge?
No.
All right, the court will accept the defendant's plea of guilt. Mr. Versace, any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted and the court does take judicial notice of Ms. Conger's judicial confession. Anything further from the state?
Statement, offered to the court that we are in victim compliance. We received no notification back from the victim in this charge. Is EMS tech. We have had some discussion with her. We just haven't received the impact statement back. She is related to my victim coordinator. This was more about these assaults have continued to occur. This just gave me a head, so she is comfortable with what we're doing. But we do not have an actual statement on how it's done.
Thank you, Mr. Woodward. Anything further from the defense?
Nothing with that.
Okay, all right, court's gonna review the evidence. So am I reading the evidence correctly in that Ms. Conger was highly intoxicated during this?
Yes, Judge Williams.
Yes, Your Honor. And I will say that after this, kind of happened, my client had been to rehab when we were supposed to 45 days, over 30 days, and rehab. She think we do AA at this time. I believe she's got her
So to be trying to control this time.
Is that right, Ms. Conger?
Yes.
So what are you gonna do anything for the victim in this case, the EMT that was trying to check you out and help you? You're gonna do anything to apologize or show remorse or tell them that you've gotten your life on the right track? Maybe more like an apology letter. I'm just saying it may go a long way because these men and women are, out there getting the calls and they don't get to make the decision whether they come or not. They don't get to make the decision if they treat you or not. They have to do what they have to do and they're supposed to be there to help people. And when people like yourself are intoxicated and physically assaulting them, that makes their job very difficult. So I think it would go a long way if this EMT from Christus were to receive some kind of apology letter, thank you letter, something, and then letting them know that that's not who you are. I hope that's not who you are.
Yes.
But we know it's more than that, right?
Sure. Yes.
You agree with me or
Yes.
don't agree with me? I mean, it says there's alcohol in there, you refuse to take a breath test, and they're telling me you've gone to AA. So I mean, it's part of addressing a problem is saying you got a problem.
Yes. Yes, I do.
So if you were intoxicated that night, I think they arrested you for public intox. If it was alcohol related, then own up to that and
Yes.
let them know that you've got a drinking problem and you've got an alcohol problem and that you're getting help with it and what you're doing to try to ensure that this doesn't happen again and that who you were that night, either you're a terrible person who's just assaulting a paramedic EMT when they're trying to help you, or you're not a terrible person, but a person with a problem who let that problem overcome them to cause this. Then I think if I were the EMT, I would want to know. I would want to know, is she just a mean person that doesn't want help, or is she someone who needed help, needed medical help that night and needs medical help going forward with your addiction?
Yes.
You understand what I'm saying?
Yes. Sir.
All right, then based on the evidence, court finds that there is enough evidence to convict Christy Marie Conger of assault causes bodily injury. Court will follow the plea agreement in this case. The court hereby convicts her of that charge, assesses her sentence as a Class A misdemeanor to 13 days confinement in the county jail, gives her credit for all 13 days served, orders a $2,000 fine, $270 court costs, $35 reimbursement fees. Court dismisses under section 1245, a resisting arrest, search or transport. Ms. Conger, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. In just a moment, I'm gonna have you be fingerprinted. As far as your court costs and your fines, if you're not gonna be able to pay all of those today, then I need you to go upstairs and make a payment plan so that you can discharge what you owe. Failure to pay those will result in a warrant being issued for your arrest, and you'll start this whole process over again. And you don't want to do that, and I don't want you to do that, okay?
Yes. Sir.
All right, Ms. Conger, Deputy Everett's going to take your fingerprint. Thank you, Mr. Precis. Mr. Manning, I appreciate it. I'm sorry to interrupt. Mr. Piercefield, come on up. All right, this is cause number CR 2275. The court is going to remove Mr. Manning based on Mr. Manning's indication that he has a conflict in this case in representing the co-defendant. The court has appointed attorney Bill Stevens to represent you, Mr. Piercefield. So I'm going to reset you. Mr. Manning, do you have any audio, video evidence that we could hand to Mr. Stevens the next?
I don't, Judge, actually, I was subbed in for Logan Sawyer, or Chief Chapter. I thought it was case midstream as well.
Okay,
I got a paper discovery and I discovered the conflict.
okay. So Mr. Piercefield, I'm going to reset you. You know, Ms. Abraham, Mr. Stevens has told me numerous times, I can't remember, he usually has a Kaufman County day or a Henderson County day. One day, Tuesday or Thursday is better for him. Do you know what?
We set Mr. Bill Stevens on Mr. Shitty's case November 22nd, so it'll be here, that's the day your request on the waiver of arraignments.
Oh.
That maybe.
Yeah, I thought about maybe moving those cases though, because we only had 2 set for that day, but I guess more have been set. Thought about moving. Yeah, it's the Tuesday right before Thanksgiving. Thought about moving some of those. But do you know if it's a Tuesday or a Thursday? But you're saying that we set it on a Tuesday?
That's the court said
Probably a
his
Tuesday.
other case on the 22nd, that's the only.
I'm gonna set it for Tuesday, December 13th. Okay, it's a little longer. I'm gonna do that for Mr. Stevens, your new attorney, for his benefit, so that he can get with the state and get the discovery, get up to speed, talk to Mr. Manning if he needs to, talk to your former attorney if he needs to. Here you go, Miss Abraham. Do you want this back? It's this. You're welcome. Sorry about that, Mr. Piercefield. We'll get you. You've gone through, this is your third, maybe the third time's a charm.
Yes, sir.
Judge, we're ready on Miss Williams, Katie Williams, Mr. Schmidt, and Jones.
Sanaya Jones. Senya? I'm gonna butcher it. You watch. I may come up with something really unique like Sanaya. Sanaya. Yeah, go ahead and bring them in, Mr. Manning. We'll do then.
You're gonna say that.
Yeah. And I'll say, well, that was the first and only time.
That's the-
It won't happen again. It gets interesting trying to make sense of some of. Are you Miss Jones or Miss Williams? Miss Williams? All right, you're Katie Renee Williams. All right, this is CR 22-299. Miss Williams, you've been charged with the state jail felony offense of theft of property, $2,500 to $30,000. You've requested a court-appointed attorney. The court's appointed Mr. Richard Schmidt to represent you. Mr. Schmidt's co-counsel here, Mr. Manning, is going to stand in for the purposes of arraignment today. Just ensure that your name is spelled correctly in the indictment, that you know what you're charged with, and then we're going to reset you. And Mr. Schmidt will be appearing with you in the future at future settings. Okay. All right. Go ahead, Mr. Manning.
Judge, this one is a representation charged against certain punishment. Please, I'm going to request to be set for pre-trial.
All right. Court will find that Miss Williams is indigent, has appointed the Honorable Richard Schmidt as counsel. Court finds that Miss Williams has waived the formal requirements of arraignment. Will enter her plea of not guilty into the record, and will set this matter for a pretrial hearing on Tuesday, December 13th. Is that the date you said? Did you have a date you requested, Mr. Manning?
No, Judge,
I think that's when we've been setting some of his. just because I think he's been getting kind of full. So Ms. Williams, I don't know if you've met with a pretrial release officer yet. You have done that, so you've gone over your conditions. You know what's required of you, what's expected, and you understand what happens if you violate those. Okay, all right, once you sign and get the yellow copy, you're free to go. Are you Miss Senior Jones? All right, step on up. This is CR 22326. Ms. Jones, the court has appointed Mr. Manning here as your attorney, and you are set for arraignment today. Go ahead, Mr. Manning.
Judge, Ms. Jones' name is spelled correctly. She understands charges against her. Main punishment for those charges, going to discuss her situation, she said, which be not guilty, and request to be sent on December 1st.
All right, court will find that Ms. Jones has waived the formal requirements of arraignment. Court will enter her plea of not guilty into the record, sets her for pretrial hearing on December 1st at 9 a.m. And Ms. Jones, Mr. Manning, has Ms. Jones signed her conditions of pretrial release? Okay, yeah, meet with those pretrial release officers and then you'll be free to go after that, okay? All right. You're welcome.
She remembered the name.
Mr. Manning, let's go ahead and reset Ms. Rios, CR 21309. Do you know how long she may be in Denton County?
I don't, judge, it appears there was a failure to appear on issue on her case there. In Denton County, that appears to be the one that she picked up on. Other than that, the only other information I have is that she was picked up on, looks like October.
You anticipate a 1716 or anything from Mr. Brockway?
Judge, in my understanding, was that he did not file anything at this point in time. I don't know if he's had a chance to file since then.
I know, I saw him up there. So here it is. Decision on this, you may have some more information.
We know what kind of charge she's being held on?
Lewis, motor vehicle.
We know if it's an older charge or a newer charge?
2020. He's like,
He's left.
if you like, it's.
No, that's okay. That's right. All right, the court's going to reset Ms. Rios for docket call and status of custody on that December 1st date. Not, yeah, December 1st.
Just want to set it at 9 a.m.
We'll leave it at 9, see if she makes bail. If she ends up in custody, we'll just slide her down the docket. I'm still checking on Mr. Balboa, and then we're still waiting to see if Mr. Jones shows.
Mr. Barnes is out there, having. Instead of. They have all that discuss.
Yeah, sure.
The thing, they, I think we focus it on.
Absolutely. Mr. Martinez. Well, you know what? I don't have Miss Grisham, so hey, just have a seat in just a second. I'm gonna call your case, okay? Mr. Martinez, you're not requesting, are you gonna be requesting a court-appointed lawyer? You're gonna be hiring one? Okay, all right, as soon as my court reporter gets back, I'll call you up. We'll put that on the record. I'll give you a new date and give you time, okay? All right, you're welcome. Go ahead and give me a notice and setting. I'll fill it out. CR 22-307 and 277. Okay.
I'll be for Martinez or I'll be Martinez. Okay, so I think that's the way it is, but in most places. It is switched. I just want to make sure the previous.
The reason. Yes.
All right, you ready to start? All right, Mr. Martinez, if you'll step on up. This is CR 22-307-277 State versus Elkin Cornelio Martinez. Mr. Martinez, you're set for arraignment on 2 charges today. One of those is a 3rd-degree felony offense of possession of a controlled substance between 1 grams and 4 grams. That carries a range of punishment of a minimum 2 years in prison to a maximum 10 years in prison. Also, a Class B misdemeanor driving while intoxicated that carries a range of punishment of a maximum 180 days confinement in the county jail and a fine not to exceed $4,000. Okay, I'm sorry, $2,000. And on the felony case, a fine not to exceed $10,000. Okay, so that's your possible punishment ranges. And you've indicated to the court that you want to hire an attorney to represent you. Is that correct? So, Mr. Martinez, if I reset you for about 30 days, do you think that'll give you enough time to hire an attorney so you can come in and have representation?
I'd say 60, but because I have the payments for my car payments is really high and I have 1,000, almost 1,000 each month, and after these maybe 2 months, so I'll be able to hire my attorney. He said that he could start is 2,500 that I was building.
Who's the attorney you've been talking to? Mr. Estrada, Edward Estrada? Okay. I can't go out 60 days. I can go somewhere in between. I can give you to about December 1st. And you just have to figure out how to make that work. Okay. All right. The court's going to reset you until Thursday, December 1st. That will be at 9 a.m. And we will not be in this courtroom, Mr. Martinez. We'll be in a courtroom across the street in the Justice Court. Okay. Ms. Tabram, do we know if Mr. Martinez has conditions of pretrial release?
Yes.
He does? All right, thank you. All right, so Mr. Martinez, I need you to have your attorney hired by that date, so you may have to ask friends or family or figure out, take extra jobs, do what you gotta do to get them hired and bring them back with you, okay? All right, we'll see you back on December 1st.
update on Mr. Balboa. I didn't have any direct contact information for him, other than an address. I ultimately met with him in court. However, Ms. Abraham informed me that she contacted his bondman and they are in the process of trying to get there today. And asked maybe if we could have him come to the jail without. Sure that. On.
The problem is he's not gonna be able to go into the jail.
Will the court be having him in the jail here? Okay, so if you show up here, I can go over and go to jail. Study fund.
I mean, we can do that. I don't know if it'd be fine, but we can do it.
Okay.
I'm not, I don't want him thinking he's gonna show up at 1:30 and everything's gonna be okay, because
Judge, I just, like I said, I don't have any direct contact information. So, I don't know if this situation is maybe reasonable explanation. So,
we'll tell him this. We'll tell him that he's got until 12 o'clock. He's got an hour and 15 minutes to show up. If he doesn't, we'll not sign. He can turn himself in. We can deal with him later.
Okay.
That way you're not hung over waiting for held, not hung over, held over. I didn't say hung over, Mr. Me. Held over from this afternoon. Y'all knock it off. Held over from this afternoon and you're waiting around. So he's got an hour and 15 minutes to get here. I'm gonna forfeit his bond. And then of course, his course.
And I'll reach out to the bond. Mr. Jones, so we did get confirmation that it's had official business in Sheridan County on today's date. And that was sent this morning at 9. Or 5. And then I think that leaves Mr. Barnes, and I'm ready to reset him.
So we expect him to be appearing at some point today.
That's my understanding, Judge.
Okay. Well, since he's got this in his corner, then we'll let him appear this afternoon. We'll let him appear as soon as he can. And if it's this afternoon, he can appear here, and then you can come over after Joe.
Perfect. I would probably, if people want to zoom in, I'll go over there.
We can do that.
Pretty much Barnes.
All right, this is Jason Lee Barnes, CR 22-201, set for pretrial. Go ahead, Mr. Manning.
Judge, we have this pretty about this time, we're in the works of getting a negotiated settlement in this. But it's gonna, I think we're released from our client. We're gonna get the release executed and get the documents to the state. We request reset date for 11/10. And then, I think, bring in the additional.
All right, court will set Mr. Barnes for additional pretrial on November 10th at 9 a.m. Mr. Waddell, before you go, Mr. Barnes, Mr. Waddell, what's the update? I show that he didn't report in September and he hasn't paid anything. We have any update on that, or is that still the case? Non-reporting, non-paying? Okay.
Your Honor, it may take some special effort to work with Mr. Morris on pushing him to report. Go a little bit above and beyond using circumstances. It's paid.
Okay. All right, Mr. Waddell, then I trust that you're supervising him and court will then see him back in, what date did we say, November 10th? All right, Mr. Barnes, you're free to go.
Thank you, sir.
You're welcome. All right, the court has called Richard Jason Balboa at 9 a.m. He was not present in the courtroom. His name was called loudly, distinctly 3 times in the courthouse. Any response, Deputy Everett? There being no response, the court's going to take judgment nisi under advisement until noon. If Mr. Balboa appears at noon, then his case will be entertained on or before that or this afternoon. Court has also called the name Dennis Ray Jones. Mr. Jones, the court notes, had business in Cherokee County. The court has received what appears to be official confirmation of that. Court will, the court has called his name. He's not present today. His name has been called loudly, distinctly 3 times in the courthouse with no response. Is that correct, Deputy Everett?
Yes, sir.
The court's going to take a judgment nisi under advisement for Mr. Jones until later this afternoon, say 3 p.m. All right, so court's going to stand in recess until 1:30.